Hello friends, I am from Sridhar Dayal Law Firms, advocates for the Honorable Supreme Court of India and various high courts in the entire country, and we also do some court cases in the lower courts as well upon demand. So let's talk about today on the doctrine of stare decisis. Alright, this is called doctrine of stare decisis, which has two ingredients. One is Obiter Dicta and another one is ratio Decidendi. Obiter Dicta is the observations made by the court, and the second thing, ratio Decidendi, is nothing but the reasons given in that particular judgment. So when we talk about the Obiter Dicta, this Obiter Dicta is not valid in the entire world, those particular courts and those particular Supreme Courts or High Courts. Whereas in India, if Supreme Court delivers a judgment or an order, the Obiter Dicta is entirely binding in the entire nation. Number one, by virtue of Article 141, which is binding on the entire courts below in the country, across the country, whether it is subordinate courts like high courts or even the courts below. And second thing, like also under Article 144, even the civil and judicial authorities are also have to obey those particular judgments and orders delivered by the Honorable Supreme Court of India. Alright, this is about the Obiter Dicta. Any observations? But this will be on the question of law, and the whomsoever, like the whichever the court is adjudicating on your matter, if you bring this particular order or judgment to the notice of those particular courts, then they will decide, like based on your facts and circumstances and the question of law, whether to consider this particular aspect or not. But by virtue of 141 and 144, all these both these ingredients of Obiter Dicta and ratio Decidendi, both are binding. This is called doctrine of stare decisis. And the next thing, if you see, even if you have Article 142, which is rarely exercised by the Honorable Supreme Court of India, like they have exercised in the Ayodhya dispute, wherein if the Supreme Court does not have any valid statute at that particular point of time, then they can exercise this inherent powers of the Honorable Apex Court, which are vested by the Article 142, which is quite famous. Alright, and of late the Honorable Apex Court has been using this on a little more frequently. Otherwise, I would guess like in the last 70 years they have hardly used it, less than 10 times. And I feel like in the last one and a half year they have used it at least 4 or 5 times. In one divorce case also they have used this, and in one more particular case they have granted some compensation. So let's see what are the judgments which make this Obiter Dicta and ratio Decidendi binding on all the courts below, including the high courts. Alright, so there are 6 judgments. If you see, one is Oriental Insurance Company versus Meena Varial and others, 2007, SEC 428. And second is Peerless General Finance and Investment Company versus Commissioner of Income Tax, 2019, SEC 851. And third is M3M India Private Limited and another versus Dinesh Sharma and another. This is dated 4/9/2019. And the fourth one is Suganti Suresh Kumar versus Jagdishan AR 2002, SC 681. Fifth one is South Central Railway Employees Cooperative Credit Society Employees Union versus Yashoda Bai and others, SEC 727. And the last is Mohandas Issardas and others versus Sattananthan and others. This is AR 1955. In all these particular judgments, 6 judgments which make the kind of a law, it's a law, okay, you can say it's more than a law declared by the parliament. Why? Because these are the judgments of the Honorable Apex Court of India, as I already told you, under the articles 141, 142 and 144. Each and every person in the country, every judicial court which is below the Honorable Apex Court, and every subordinate court like high courts or even the courts below or sessions courts or even the civil and other authorities, they have to obey these judgments. And in these judgments, the Honorable Supreme Court has even issued a salutary clarion. That's a kind of warning to the, particularly to the high courts, to introspect the judgment given by the circumspect the judgment delivered by the Honorable Supreme Court of India very carefully. Okay, why? Because so that in order to avoid per incurium is nothing but like a not to care at all. So if some court below, whether it's a high court or the court of magistrate, if they don't consider the question of law delivered by the Supreme Court's judgment, then it will become a per incurium. Normally in the courts, what we see, most of the advocates in support of their cases, they bring certain judgments of the Honorable Supreme Court and they call it citations. They file 5, 10, 50, 40, whatever it is. But the important point is they are not mere citations, they are not references. What way, what perspective you are looking at is more important. Here the Honorable Apex Court of India has delivered a judgment in which on the particular question of law, or on the particular question of law, they have taken a stand in the form of the observation or a reason. So both of these things are binding for the interpretation of the law. As under 141, 142 and 144, the entire country is bound by that. And another best example what I would like to give you is the collegium system of the Honorable Supreme Court of India. The judges of the honorable high courts are selected by the collegium which sits in the Honorable Supreme Court of India, which constitutes constitution bench judges, 5 top-notch, top 5 judges, including the Honorable CJ of India. Okay, so these honorable judges, they decide the incumbents in all the respective high courts, all the justices and their transfers and everything they have. And how did they get that power? There is no statute in India which empowers them at present. Since last 2 to 3 decades, there are 3 judgments. Okay, there are 2 judgments, and one was in the form of a letter, a reply to the President of India, Honorable President of India, that the CJ of India has clarified about these particular judgments and the law. They have declared a law. Okay, and by that virtue of those judgments and the law, the Honorable Apex Court is completely inherently empowered to select their own judges. So you can, and it is binding, and the central government has got nothing to do with it. And if you see even the NJAC, National Judicial Appointment Commission Bill, I think it was presented in the year 2060 by the Modi government, which was struck down by the Honorable Supreme Court of India because of the lack of merits. Why? Because the Supreme Court of India has completely taken over the entire judiciary's, the subordinate court's judiciary's supervision. Alright, therefore, their judgments are as good as and even above the laws declared by the parliament. Alright, and next, if you see, I have given you the 6 judgments on the Obiter Dicta. Okay, even if there is any observation, not oral, only particularly in written, in particular judgment, so that if at all it is concerned with any question of law, it will be definitely binding. So don't treat it as some kind of citation. They are not citations, according to me at least. It's my personal opinion. They are binding, there's no doubt about it. Alright, and the next thing, yes, and one more point I would like to bring it to your kind attention is, what if the court below or a subordinate high court does not obey those judgments? See, there is nothing much that you can do in that particular case. Why? Because if it is any other authority or any person, private person or any other parties, there is ample scope that you can proceed against them straight away, either through the Article 129 in the Honorable Supreme Court of India, or by virtue of Article 215 in the Honorable respective High Courts, under Contempt of Courts Act 1971. Okay, that will be a civil contempt. Alright, any authority or people not obeying the orders and judgments of the Honorable Apex Court, they are like contempt, but they are valid for the civil and other authorities and private parties. But when you come to the subordinate courts and the trial courts, I don't think so they will be entertained much, because it's a bad luck that those particular courts are not honoring the judgments of the Honorable Apex Court of India. But if you see, there is a provision. If you see the Contempt of Courts Act 1971, there is a section 16 which says that contempt by a judge, magistrate or other person acting judicially. subject to the provisions of any law for the time being in force, a judge, magistrate, or other person acting judicially shall also be liable for contempt of his own court or of any other court in the same manner as any other individual is liable, and the provisions of this act shall, so far as may be, apply accordingly. So this says there is, if at all there is any other law being in force. So I would like to bring one more act to your kind information, that is Judges Protection Act 1985, if I'm not wrong. That particular act provides immunity, I think, that is to the judges of the subordinate courts, the high courts, all right. But whereas magistrates are prone, they are prone for the contempt of the Supreme Courts, but definitely there might not be strict action if you move a contempt petition in the Supreme Court of India under 129, or a contempt case in the High Courts under 215 articles, or this particular act of Contempt of Courts Act 1971. I don't think so the courts will entertain any petitions on the magistrates or court below, or the judges of the court below, alright. And if at all you dare to move any application, alright, in the Supreme Court of India against any high court judges that they have not honored the judgment of the Honorable Apex Court, better be careful. You will, the Honorable Apex Court of India usually imposes a fine of minimum 5 lakh rupees, and you hardly get a week's time or 10 days time, within which if you pay the money, otherwise fine, otherwise you will be taken into judicial custody. So don't venture into such kind of things. That is my personal advice. And the next thing, that's all. I think I have spoken on the ratio Decidendi and the Obiter Dicta, which constitute part of state decisis, which are very important parts in the jurisprudence. So wish you all the best. If you have any queries on law, you can always talk to me. We are located in New Delhi, in Karol Bagh in New Delhi, and also in Hyderabad as well. We operate across all the subordinate courts in India, any high courts, and particularly in the Supreme Court. We deal with the contempt petitions, we deal with the SLPs, and we also deal with the writs. Alright, thank you so much.